Good afternoon. Calling the case of TPOAM versus Renner. This is a full grant, 20-minute argument per side. You have 2 minutes of a free fire zone, and you may waive that, and you may also reserve time for rebuttal, but we ask that you keep track of your own time, and you can begin when you're ready.
Good afternoon, Chief Justice, Justices. May it please the Court. Frank Guido, General Counsel to the Police Officers Association of Michigan, appearing on behalf of the appellant, the Technical, Professional, and Office Workers Association of Michigan. Time permitting, I would like to reserve 3 minutes for rebuttal. There are consequences to the exercise of free choice. Mr. Renner exercised free choice. He chose to not be part of the union, to not pay dues, knowing that one day he might need help from the union. The consequence of that exercise of free choice is that if Mr. Renner wants to demand direct representation services, he must share fairly in the cost, and he cannot do so with demand of others to pay for him. Now, one of the claims of appellee is that he's not being treated equally, and that argument is hypocritical. Appellee demands preferential treatment, entitlement to free services, that others bear the financial burden for his demands, and that's not equality. Appellee claims that the union, as the exclusive representative, cannot charge fees, that there is no financial connection between a union and its membership. If that argument were valid, a union could never charge dues. PARA is silent on dues, yet they're allowed because Section 10 of PARA allows a union to create its own internal rules, and in doing so establishes a basis for dues for membership. Please understand that the concept of the exclusive representative is most germane to the relationship between the union and the employer, because the employer can only deal with the designated exclusive representative. Now, appellee's argument is in essence a smokescreen because it also is at odds with the guidance that we have from significant cases, the Janus case, which I will talk about more later, as well as this court's own Goolsby case from 1984. Both of those cases recognize a financial link between the union and a bargaining unit. Appellee also claims that the pay-for-services procedure of the union can only be lawful if the legislature amends PARA. There's no need to amend PARA. The concern is not whether the legislature has to amend PARA to allow a pay-for-services procedure. It is whether the legislature has ever amended PARA to prohibit a pay-for-services procedure, and it has not. In fact, the recent amendment of PARA, Public Act 9 of 2023, this year, supports our position. The legislature did not take any steps to prohibit a pay-for-services procedure, but to the contrary, the amendment reemphasized the public policy of this state, that all employees, quote, share fairly in the financial support, unquote, of the union to maintain, quote, stability and effectiveness of labor relations, unquote. This court raised questions for the parties to address.
But that amendment was different than that. What you're not? Are you saying that that would allow the fee in this case? That amendment?
No.
Okay.
That's placeholder legislation.
Got it.
That
Okay.
only becomes valid if the Janus case is overturned.
Of course, right.
But it speaks volumes about what is the intended policy of this state.
Got it.
So this court raised some questions for the parties to address, to distinguish between the common law breach of the duty of fair representation from the PARA Section 10 violation for restraint or coercion of the exercise of Section 9 rights. There's no dispute, I don't think the parties dispute at all, that these are separate claims with different kinds of standards of consideration. But let's look at a DFR claim. Michigan adopted the DFR standard in 1984 in the Goolsby case. The court in Goolsby made several significant pronouncements. It said, the union's first duty is to be concerned with the common good of the total membership. The good of the total membership may conflict with the needs, desires, and rights of individual members. Where such conflict exists, it is in the union's discretion to choose the general good of the total membership over the individual. And we also note from Goolsby that there was a distinct recognition of a financial link between the union and the bargaining unit. Let's even go so far as to call it a mutuality of obligation. The court said a union speaks for the bargaining unit, negotiates contract terms, provides representation, quote, in exchange the member pays union dues, unquote. So as we look at the Goolsbee case for some guidance from some history, it tells us there's 3 independent bases for a DFR claim, and I'll call duty of fair representation a DFR claim. Arbitrary conduct, bad faith conduct, or discriminatory treatment. Only discrimination is at issue in this case. That is the only area that Merck and the Court of Appeals ever addressed. And the test for discrimination is, again, we believe undisputed, substantial evidence of discrimination which is intentional, severe, and unrelated to a legitimate business objective. There is no breach of the duty of fair representation in this case because our pay for services procedure reflects a legitimate union business objective.
Counsel, how do we square that historically in the state, para has been interpreted in a way, the same way the NLRB has interpreted the companion law? So how do we square that to get to what you want us to do?
Right. When we discuss the fact that there are several old administrative NLRB cases, one is the machinist case, which was a 2-to-1 decision of the board, and then there is a allied case, which was only an ALJ decision, not even the full board. Those cases, for lack of better argument to say anything negative about them, were poorly reasoned. They're pre-Janus cases. They don't recognize and never did recognize that members pay dues for services. So when the equality argument was raised in those cases, they missed the boat. They missed the argument completely. And we think Janus and subsequent cases that we'll discuss, such as the Sweeney case and the case from Pennsylvania, have recognized, wait a minute, you can't simply say that there's an inequality situation here. So those cases that exist, especially those 2 that I have mentioned, are not the guiding star for us in this particular state under para for our consideration. But as I was indicating, legitimate union business objectives is a distinct basis in which duty of fair representation will be shown to not be violated. And our circumstance proves the point. We maintain stability through fair sharing, through our procedure. It protects members from financial burden. It recognizes that grievance arbitration costs are substantial. It does not compel anyone to join as a condition to receive those services. It doesn't require payment as a condition of continued employment, and you only have to pay for those services that you request. Those are legitimate union business objectives. And with those in place, there is no finding, there can be no finding of a breach of the duty of fair representation. In fact, in this case, the problem with the Court of Appeals in Merck is that they reached a per se conclusion. They said by virtue of the fact that you have this, it is a violation. And per se conclusions have no basis, no proper basis under an analysis of the breach of the duty of fair representation. And I direct the court to its own case in Demings from 1985. It's a case I am intimately familiar with, as I argued that case in front of this court 38 years ago. So at that time, the court in that case said, a per se conclusion has no place in a DFR inquiry. There's no DFR breach here. Likewise, there's no statutory violation under Section 10 and 9. Section 10 doesn't focus on that same 3-pronged test of a breach of the duty of fair representation, the arbitrary, bad faith, discrimination standard. So we ask, what conduct does it look at? We submit that Section 9(2)(a) and B is the appropriate section to look at because it speaks of the conduct of a party other than the individual and talks of a person, we will say the union, using force, intimidation, or unlawful threats to compel a person to join. We didn't have any finding in this case that any of those circumstances existed. Now, appellee claims, oh, you can't use 9(2)(a) and B because there's no legislative history to support what you're saying. And we submit that none is necessary. As the Court of Appeals in a recent decision in Bate versus City of St. Clair Shores, issued in August of this year, citing this court's decision in In Re certified question from the United States Court of Appeals for the Sixth Circuit, 468 Mish at 116, said very simply, indeed, this court does not resort to legislative history to cloud a statutory text that is clear. We submit that Section 9(2)(a) and B is clear, and because Section 10 of para speaks of the conduct of a labor organization, we must then look to Section 9 to find what part of that statute talks about the conduct of individuals other than, for example, Mr. Renner as the employee. And 9(2)(a) and B is that only section and therefore relevant. But whether we look at 9(2)(a) and B as being operative or the less relevant 9(1)(a) and B, there's no para violation either way under Section 10 of the Act for fundamental reasons. Mr. Renner was not required to join the union as a condition to receive services. He only had to pay for the services he requested. He did not have to pay as a condition of continued employment. That means to keep his job, obviously. And the pay for services procedure of the union addresses legitimate union business objectives. And then one other critical fact. Section 10(2)(a) lets a union create internal union rules which exempt it from the Section 9 scrutiny of the Act. And let's explore that last point. Internal union rules are allowed. We submit that our rule fulfills the nature of an internal union rule. If the rule does not contravene a plain, embedded, or overriding policy of para, we submit that it's a valid rule. If the rule addresses legitimate union interests and objectives, we submit that it's a valid rule. If it does not prohibit leaving the union, it is valid. If it does not mandate payment as a condition of continued employment, it is valid. And I'm not pulling those out of the air. They are the underpinning to the United States Supreme Court's Schofield decision in terms of to the extent to which internal union rules are valid circumstances. And our rule addresses all of the things that must be addressed with acquisition and retention of bargain unit membership. It talks about membership in the union, joining and paying dues, opting out and still being in the unit, collective representation, direct representation, fair share responsibility, delivery of services, and the ability to rejoin the union. So not only do we have para saying your pay for services procedure is allowed, we believe para also says the converse, that it's not prohibited, because Section 10(3)(c) of the statute says that we only prohibit payments if they're compelled as a condition of continued employment. Now, Merck and the Court of Appeals lost focus here because they said, well, terms and conditions of employment are affected. But those two terms of art are not the same. The phrase terms and conditions of employment pertains to what are bargaining subjects under para, what are mandatory subjects of bargaining, whereas the phrase condition of continued public employment pertains to job retention. There is a big difference between the nature of those two items. Now let me turn, if I could, to Janus and the progeny of Janus, because we believe it's very significant to this case. Whether we consider Janus's language dicta or not, the court was clear. Whatever unwanted burden can be eliminated. Individuals can be required to pay for that service or could be denied union representation altogether. Again, we can pretend like Merck and the Court of Appeals that those words are not significant, but that would not be true. They are significant. The court could have simply said, there's no link between financial considerations and the union's duty to provide services, so provide it for free. That's Appellee's argument. The court did not say that. The court could have said, well, you're the exclusive representative, therefore you must provide that service for free. The Supreme Court did not say that. The Supreme Court said you could be required to pay or denied representation altogether. And we have more guidance after Janus. I direct you to the Sweeney versus Raoul case, a 2021 Seventh Circuit decision. That's a unique case. The court was confronted with a union action concerning a non-member having to pay for services. And it was actually in the nature of kind of like an advisory opinion request or declaratory relief, which the federal court doesn't do. And so the court said it's not right for us. But
So if we were to agree with that interpretation on Janus, which I agree, that is what they said, I mean, do we really think the Supreme Court, in one line, like pretty much undid one of the most basic premises about unions and, that you are the exclusive bargaining agent, understanding there's exceptions in some states where they can get around that, but is that?
Well, the Supreme Court in a lot of lines undid 40-year precedent that existed before that time.
Oh, absolutely.
So,
those were holdings, though. But
yeah,
this was like a kind of offhand
right.
statement.
And that's why I think it's significant to see what Sweeney said and then the Taylor case, which I'm going to mention in a moment, because they moved that needle from a concern, well, was it just dicta, or were they actually saying something more substantive to putting it into actual application. So we have the Sweeney case, and here's what the court said, which I think is very telling. Quote, doing so will give all involved an opportunity to fully probe the extent of a public union's obligation to fairly represent a non-member who pays nothing for services rendered. Indeed, the union's proposed solution proves the point. After explaining the predicament the union sees as created by Janus, Local 150 emphasizes an alternative prescription mentioned by the Supreme Court itself, that the union be able to charge non-members the costs of representation in grievance proceedings. So yes, Sweeney said what it said, but as far as we're concerned, that's moving the needle towards saying this language merits consideration as being applicable. Well, wait, we have more guidance. Let me take you to the 2023 Taylor versus Pennsylvania State Corrections Officers Association decision. In that case, an employee challenged the union's pay for services procedure. The employee claimed denial of equal treatment. Does that sound familiar? That's Appellee's argument in this case. The court rejected the argument on the same basis as the arguments in our case. It said, one, Pennsylvania state law does not prohibit a pay for services procedure, and the Janus guidance is compelling. The court held, charging fees was not made a condition of continued employment. That's our argument. The court said charging fees is an exchange for services. That's our argument. The court said pay for services procedure is precisely the arrangement described by Janus. That's our argument also. And the court said there is no per se violation of the duty of fair representation with a pay for services procedure. Once again, that's our argument. And in fact, the court even talked about that footnote 6 of Janus and concluded that the pay for services procedure fulfilled the quote-unquote alternative as suggested by Janus. So we've got Janus that provides guidance. Sweeney, we believe, implies strongly that Janus is more than mere dicta. And then we have a declaration from the court in Pennsylvania that validates a pay for services procedure if, as here in our case, two things happen. It's not prohibited by your statute, and the union does not charge the fees as a condition of continued employment. See, my time is going, so I want to state that free choice truly is a two-way street. Please remember the example I previously stated to the court during the argument on the application. You've got Mary sitting here. She's a 20-year employee, maybe more, paying her dues monthly, yearly, faithfully. And then you got John over here who is not paying dues. And John points to Mary and says, hey, Mary, I'm in trouble. I'm demanding to go to arbitration, and guess what? I don't have to pay a dime. You got to pay for me. And there is absolutely no logic in that unfairness. If the Court of Appeals decision and the Merck decision allowed to stand, it is truly going to be damaging to organized labor. Members like Mary will become frustrated, and they're going to give up, and they're going to leave, and it is already happening. The stability and effectiveness of organized labor is going to be irreparably compromised. That outcome is contrary to PARA, and that outcome is contrary to the public policy of this state, which is to share fairly. Thank you.
Good afternoon. May it please the court. David Porter here on behalf of Daniel Renner, who is here today with me in the courtroom. Your Honors, the union in this case tried to charge Mr. Renner a fee for a service it was already obligated to provide. Now, the four largest public sector unions in this state, the AFL-CIO, the MEA, the AFT, and AFSCME, all agree with Mr. Renner that this violated their duty to fairly represent Mr. Renner. In the words of their amicus brief, the fee-for-service provision violates their, quote, fundamental mission and purpose of labor organizations. They oppose what the union did in this case because they recognize it is a drastic departure from their longstanding legal obligations, and because they and every other amici in this case recognize that their argument will drastically change labor law here in Michigan, and not for the better. Not for employees, not for employers, and best of all, not for unions. It is precisely for this reason that the NLRB, for decades, over the course of multiple presidential administrations, has rejected fee-for-service provisions just like this because it violates the duty of fair representation and it unlawfully coerces employees in the exercise of their statutory rights. The administrative law judge and the commission, both of whom have substantial specialized experience applying our state's labor law, wisely followed that persuasive authority, as did the Court of Appeals in a well-reasoned published decision. This court should heed that collective wisdom, and it should either affirm or dismiss the application as improvidently granted. Now, I'm happy to answer any questions the court may have, but I will turn first to the request to dismiss the application as improvidently granted and address what has developed since this court granted leave, and I'm referring to Public Act 9. What Public Act 9 did is eliminate the statutory right to refrain that is central to the question of coercion before this court. Now, the statute doesn't apply to the facts of this case because it is prospective only, and therefore the union's conduct needs to be judged under the statutory regime that existed at the time. However, when it eliminated that statutory language, the legislature effectively eliminated the jurisprudential significance of that question. Anything this court says with respect to the coercion question will apply only to the parties in this case. It will have no wider application to anyone else in the state of Michigan. And this court does not spend its precious judicial resources answering such academic questions. So for that reason, we think the most prudent thing to do, at least with respect to the coercion question, is to dismiss that aspect of the application as improvidently granted. Now, what the new law did not do, and it doesn't touch, is the duty of fair representation question, and so I will turn to that next. And like Justice Bernstein, I think it's best to keep it simple, and I know this can be complicated, so I think this issue can be summed up in just two words. It's power and responsibility. With power comes great responsibility, and anytime we are talking about the responsibility, the duty to fairly represent, we have to keep in mind why they have that duty to begin with. And that's the power that they are granted when they become the statutory exclusive representative. That designation comes not because anybody pays any money, dues or otherwise, but because the union has voluntarily agreed to seek that statutory designation, knowing that they are not entitled to any financial contribution whatsoever under the statute. Brother counsel just told you that para is silent on union dues, which proves our point that financial contribution is not inherent in the relationship between the union and the bargaining unit members. The true quid pro quo of para and the NLRA is the exchange of rights and responsibilities that comes when the union becomes the exclusive representative. The employees give up the right to control their own economic destiny. They instead rely solely on the union to look out for their best interests. The union, in turn, gains substantial power. Only they can sit at the bargaining table with the employer, not the individual employees, and not other unions. And the employer has to listen. The union, in conjunction with the employer, can determine when employees have to show up, when they can leave, what they can do, what they can't do. Individual employees like Mr. Renner no longer have any say over the most important terms and conditions of their employment, including working out disputes with their coworkers and their employers. The union in this case, like almost every other union, when it negotiated this agreement, reserved for itself the sole and exclusive authority to prosecute and process grievances. It excluded employees like Mr. Renner and dues-paying members from the process entirely. So with that great power comes great responsibility, and that was born the duty of fair representation. That duty entails the right to not act arbitrarily, to treat everyone equally, and to act in good faith. In the context of carrying out grievances, it means you must treat all bargaining unit members the same, regardless of whether they, in this case, are dues-paying members or not. That is why the duty of fair representation exists.
Counsel, do you, the Court of Appeals opinion, I know there have been concerns raised by amicus that there's sort of a conflating of standards, that you had the right to work statute, and then you had the duty of fair representation, and sort of talk about coercion, and it sort of got worked into both standards. Is that something that we need to clean up?
No. The Court of Appeals opinion in this case is consistent with the analysis in the long line of NLRB precedent that we've seen that talks about why fee-for-service provisions like this are coercive, because they discriminate against the employees for being non-union members. You become a non-union member, a non-dues-paying member, because you've exercised your statutory right to refrain from financially contributing to the union. So in this case, although they are, I agree, independent claims, independent lines of authority, in this case they merge because by discriminating against non-union members, you are discriminating against somebody for exercising their statutory right. And when you do that, you necessarily coerce them in the exercise of that right.
Even talking post, 2023 moving forward, so you're just talking for this case?
In this case,
Right,
yes.
yes.
So we happen to have the exercise of a statutory right also be the protected status, if you will, under the duty of fair representation. But that protected status still exists even post-2023 in Public Act 9. You have a constitutional right under Janus not to contribute financially to unions as well. And even before Janus, the NLRB and the United States Supreme Court has long recognized, going back to the very first decision in Steele, yes, the non-union members there were African American, but they were also not allowed to be dues-paying members. They were both. So non-union member status has always been protected under PARA and the NLRA, and it will be even after 2023, despite the legislative amendment.
Are you aware of any decisions from the federal court or the NLRB that has approved differential treatment on the basis of union support when there's no union security clause in place?
No, I'm not aware of any case that says that. It's an unbroken line of precedent. The only authority out there to the contrary is the Cone case, which is the Nevada case, which we've argued is distinguishable because the employees in that case weren't entirely excluded from the grievance process. They could pursue the grievance themselves. It's important to note that Cone was a coercion case and not a DFR case. And so with respect to answering what we think is the only live issue in this case, Cone is really beside the point. Now, there has been discussion of Janus and the import of Janus in this case. Janus, I think there's two important points to make about Janus. First, it largely agrees with us on the most important parts of what is in dispute, which is individual grievances are not an individual benefit. They benefit the entire bargaining unit. That's just why the union has so much power in the processing of individual grievances. Second, they made clear that it is not unfair to represent non-union members despite the fact that they would not be able to pay. Now, right after that, Janus did mention that a less constitutionally problematic alternative could be to allow non-union members to pay for direct grievance processing. But they said it was permissible under the federal constitution, not under state laws and not under the NLRB. They weren't addressing the scope of the DFR or exclusive representation in answering that particular question. Now, they did say that states could enact statutes that would allow unions to have these fee-for-service provisions. But the legislature has the authority to define what the scope of the exclusive representation power is. As I mentioned, there's both power and responsibility. If the power goes down, so does the responsibility. So our position is entirely consistent with Janus. Janus says legislatures can come in and define what the scope of the exclusive representation power is. If they say that that power does not include representing non-union members in direct grievance proceedings, then the duty of fair representation goes down with it. But the holding that the union asked this court to announce here in this case only affects the responsibility. The status as exclusive representation will still exist. And so then you will have a fundamental question that you will have to answer in the next case. And that is, if you have no responsibility to represent them in direct grievance proceedings, how do you have the power to bind them in the first place? The sole reason why we have the duty of fair representation is because unions were able to come in and insert themselves in between employees and their employer and bind them against their will. That raised, quote, serious constitutional concerns, in the words of the U.S. Supreme Court. Those very serious constitutional concerns will reemerge if this court holds that the duty of fair representation does not apply in the absence of financial contribution. It's for that reason that the amici public sector unions have come in and argued that adopting this line of argument from the union in this case will have drastic consequences for unions going forward. We ask this court not to follow that because it will have to, as stewards of Michigan law, grapple with the jurisprudential fallout for years to come.
Could you outline what you think those drastic consequences are that they're concerned about?
Well, the first is the line drawing problem with the union's argument. They would like you to limit it to direct representation services, but counsel has already conceded that there is no legal rationale for limiting it to that setting. The union representation is a spectrum, as this court said in Cortez versus Ford. For the same reason that they can agree not to represent you in a direct representation context would apply to the bargaining table. You would then be able to bargain for different benefits, terms, and conditions for different members of the bargaining unit depending on whether they've paid or how much they've paid.
Like a slippery slope that what could be here could eventually creep up into the whole bargaining process.
That's correct. And then the entire concept of exclusive representation will then become at stake, because now you have the unions able to treat bargaining unit members differently at every aspect of the representation spectrum based solely on whether they've financially contributed to the union. That is effectively a union shop arrangement. You would have a members-only union in a state where you are bound to you are bound by whatever the union agrees with the employer. You have no more say over the terms and conditions of your employment. Again, that would raise serious constitutional concerns as a third-party beneficiary to some of these contracts. Again, all of these serious constitutional concerns were alleviated almost 50 years ago when the Supreme Court recognized the duty of fair representation.
Thank you.
So I think that's really the most important aspect of the duty of fair representation issue is the massive consequences that would come from adopting the union's position in this case. Now, like I said, I don't believe that the coercion question is at least one of importance anymore, but if the court has any questions regarding that issue, I'm happy to address them. Otherwise, we'd ask you to either affirm or dismiss the application as improperly granted.
Thank you very much. Minute and 46 seconds.
Couple. Okay, thank you. I've heard Brother Counsel speak, and I have to say that, we're playing fast and loose with what Janus was all about and what it said. For counsel to indicate to this court that, well, it was limited to a federal constitutional issue and it only says you can do something like this if there is passage of a statute is not to be found in the case. And it doesn't have that limitation at all. And we think if it did, perhaps then the Sweeney case and the Pennsylvania case would have certainly been written in a much different manner, and they clearly were not. And in noting that, I note that the appellee has not addressed the impact of the Pennsylvania case, which we believe is quite telling in terms of the direction parallel to Michigan. I enjoyed the power and responsibility argument very much, but it's a fiction created by the appellee because it's not a product of what Para says in terms
Counsel,
of...
I have a quick question.
Yes.
Do you mind if you could, responding to the amici brief from the other unions and the answer that was given to Justice Welch's question about the potential consequences?
Absolutely. We have a circumstance where there is an assertion that if this transpires, that there is going to be a Pandora's box open up and many bad things will flow from that. And that's simply not true. I can't work my way into the head of where amicus is thinking. I know that in some of their arguments they said, well, the union, being the appellant here, should not be found to have breached the duty of fair representation, but we shouldn't allow a pay-for-services procedure. Well, in response to that, I say, shame on them in terms of that argument because they're not there for their members and protecting their interests. I don't know whether it's a circumstance of they just didn't do it, they don't want to do it, they don't want the headache of the accounting to do it, or what the circumstance is for them. But a claim that somehow this is going to lead to a catastrophic circumstance is absolutely ludicrous. More important, you've got a circumstance where counsel, the appellant, the appellee, has now argued to this court that, well, this is going to lead to the union now going in and, for example, in bargaining and treating individuals who are opt-out separately. And that is an impossible circumstance to occur. When we bargain for classifications of individuals. We don't bargain for Mike or Joe or Bill. You don't do that. That's not how the nature of collective bargaining works. And for that to even be raised as an argument to this court is it's a meaningless argument, it's a disingenuous argument, and we take great exception to that. Once again, we submit that I know my time has passed, that we respectfully request that this is a tremendously important case and that this court, in fact, reverse the Court of Appeals and Merck. Thank you.
Thank you. Thank you both. The case will be submitted.